So good afternoon, everyone. Once again, all those who joined us online as well. We are going to commence the next session. So the speaker has already arrived. Just let him have a glass of water if what. Hello, sir. So, ladies and gentlemen, the next session is very interesting. I think many people had a lot of doubts on this, and you have the right person to talk about it. The special session on Code of Wages 2019, and we have barrister and partner Advait Law Chambers, Mr. Anand Gopalan, to address all on this. It's really a pleasure to see that the hall is again full, even after lunch, which is a rare sight these days. I'm sure the topics and the speakers have drawn you back again into this hall. May I now invite Mr. Anand Gopalan to take his place on the dais, please. May I have the AV of Mr. Anand Gopalan, please.
Mr. Anand Gopalan, London and partner at Advait Law Chambers, is a second-generation lawyer with over 2 decades of experience, specializing in labor and industrial laws. A Cardiff University postgraduate, Mr. Anand Gopalan has revitalized firm operations, frequently briefed senior counsel in the Supreme Court and High Courts, and conducted extensive corporate training in labor law. Mr. Anand Gopalan also plays an active policy role as chairman of the Labour Laws and Legal Committee of the Madras Chamber of Commerce and Industry and participates in major industry forums including EFSI, CII, NIPM and CROMA.
Let's welcome him with a big round of applause. Thank you for taking your time off, sir, and being with us. May I now request you to take the session forward, please.
Good afternoon. My apologies, I was a few minutes late. Jumping straight into the topic, Code on Wages. I think you already heard 2 sessions, and speakers of the morning must make it difficult for me. But other than that, I think it's also the lunch. Post-lunch session is always a difficult challenge one. So, what has been notified on 21st November, you have the codes. My PPT is there and it's MMA and NAPM can share it with the participant. I don't have a problem. So don't bother taking pictures of it. So has the code come into force? Yes, it has come into force. Rules have not been notified. That does not mean that you don't comply with the codes or you need to wait for the codes rules to come. As of 21st November, it has been notified. Therefore, from 22nd November, you are bound to comply with all the 4 codes. 2 codes to the extent they have been notified. 2 codes have been notified in total. The other 2 codes are concerned to whatever extent they have been notified, you are required to comply. So the question as to whether you can wait for the rules, in my opinion, no. The rules are procedural. They are more regulatory for the authorities how to execute it. Maybe today, let's assume somebody is going to retire or somebody is going to resign. They may not have an avenue to go and make a complaint. That's all it is. As far as you as an employer are concerned, you are required to comply with the codes. So there's no question of waiting for the rules. So I'm just trying to make it, initially, I know all of you are more keen to see on the definition of wages, which I'm keeping it to the end. Hope it's a good climax to complete it. But so let's try to make it a bit interactive. So what is the wage ceiling prescribed under the Payment of Wages Act? Okay. So what is the wage ceiling now under the Code on Wages Act? 18? 18, 21, 24, but the right no ceiling. There's no ceiling. The definition of worker under the code prescribes a ceiling for the definition of worker. So supervisory staff with a ceiling comes within the definition. So that is the only place where the ceiling is there. The ceiling is not there. Pausing here for a minute, one more usual thing that I keep saying wherever I've addressed over the last 5 years on these codes is all the 4 codes have the word employee and worker. Please see where these words are used. The term employee is much wider. The term worker is restricted. So it comes within the employee definition. So if you look at the IR code, for instance, primary usage will be of the word worker. In 16 places alone, you will find employee with very, very limited usage of it. But whereas when you come to the code on wages, you will find more of employee, not worker. So if you look at overtime here, under the code on wages, you will find the term that is being used is employee. But if you look at OSH code, and you look at the word for overtime, what is the word they have used in OSH code? Worker. So you need to be aware as to why, what is it used for. I'm not getting into the legality of how OSH and code on wages should be interpreted on this term, but so the ceiling limit is not there under the code on wages as of now, whereas it was there under the 2036 Act. So this code on wages is applicable to factories, shops, all establishments, only government offices. And if you look at it, in fact, for some reason, they've even included government offices in this definition of all establishments. So I don't know what they meant by it, but they have. So if you, the earlier parts, if you were looking, each one was different. So if you look at payment of wages, to whom it was applicable, to minimum wages is scheduled industry, and then payment of wages, bonus and equal remuneration is different applications were there. But under the code, they have tried to bring in a uniform through the to all the establishments and through the employees. That is what you will find in the code on wages. Double, okay. So the word again here is double. Impact of this, I will touch upon again once when we go into the definition of wages, why, how this is going to be impacting. Grievance under this. So authorities are going to be, again, just like Payment of Wages Act, Minimum Wages Act, you're going to have authorities. You're going to have an appellate authority also as far as code on wages is concerned. So it's again going to be your JCL, DCL who are going to be looking into any complaint under the code on wages. And there will be an appellate authority also to be formed. For instance, today it's not common. If you take the payment of wages, the appellate authority is what is we call as a small causes court. It's a civil court. Whereas if you look at gratuity, it will be within the labor department itself. So PG and PGA will be within the labor department. Here they're trying to bring in a uniform system. So under the Payment of Bonus Act, I think it's a simpler question. You have a ceiling of. So what is it under the code? So here, if you look at certain aspects, for instance, I'm just slightly deviating. You would have heard from Mr. Ravindran on the IR code. When it comes to your standing orders, as on date, Tamil Nadu has its own standing orders. Kerala has its own standing orders. But under the IR code, they wanted to have a uniform standing orders. So only the central government can give a model. So Kanyakumari to Kashmir, the standing orders is going to be the same. That's the idea. But here, when it came to bonus, they left it to the appropriate government to fix. Whereas currently bonus across India is 21,000. So these are small things, mistakes that have been committed by the legislature when they are doing. The idea is not to, leave the power to each of the states to do it. But unfortunately, that's how it has happened. So the word used in the ceiling for under the bonus, code on wages, is that the appropriate government will fix. So Tamil Nadu tomorrow can fix 25,000, Karnataka can fix 30,000. That is again going to be challenging because the profits of the same company, let's assume you are a company having operations in 5-6 states. If each state is going to fix a different ceiling, then some set of employees will get it in Tamil Nadu, whereas some set in Andhra may not get it, somebody in Maharashtra may not get it. So these kind of challenges are going to come in the bonus is concerned. So this is a case of where I am gone a little prospective here. It's a case of 26-27 where you're saying that the union has filed a dispute asking for a higher bonus. There is a litigation between you and the union. What are you required to do as an employer? You can wait for the dispute to get resolved, or what are you to do? Fantastic. Most of you seem to know more code than me. So section 39(2) mandates that a minimum bonus has to be paid. So even if there is going to be a litigation between you and your employees, it is not that you can just simply wait and arm twist them going forward saying, I will not pay, come to my terms, only then I'll pay. You still need to pay the minimum bonus. So the manufacturing sector is concerned, these certain small leverages that were there is no longer there. This concept of floor wage. Okay, central government. Central government fixes it for whom? What is this floor wage? The floor wage is in fact not a new concept. First, let's get that. It's already there. Central government can tell, for instance, Tamil Nadu government, we have seen the cost of living in your state. Your minimum of the minimum wages should be 15,000. Don't fix any minimum wages less than 15,000. So the directive, what is this floor wages is? It is a direction to the government. It has got nothing to do with any one of you. So the central government is going to tell each state government. So it could tell in Northeast in Assam, okay, your cost of living is low, you can fix 9,000, but it has to be a minimum 9,000 and above. But when it comes to a more prosperous state, it could say, no, you have to fix it more than 20,000. So that power is given to the central government. It's seldom exercised, it's already there. So this is being spoken about much, saying that this floor wages. Floor wages has got nothing to do with any one of you in this room, unless you are from a government department. So the government is going to tell the government, please fix at this rate. So they have to do it with the consultation with the state government and the central advisory board. Minimum wages can be fixed under the code. I know it's a very... Today, if you look at the minimum wages, Tamil Nadu, for instance, has around 70 scheduled industries. So from security agency to rubber industry to chemical industry to, all kinds of things, carpentry, aplam making, different things. If you look at, there are 70 different industries. So for each industry, a minimum rates of wages is fixed. Going forward, it is not going to be industry based. It is going to be skill based. It's already there even under the Minimum Wages Act. In fact, today, if you look at Delhi, Delhi does this already. So if you look at Delhi's minimum wages, you will find 10 standard, 12 standard, degree holder. So based on educational qualification, minimum wages is fixed. Apart from it, driver, security guard. So that's all common. But today, if you look at it, you take our Tamil Nadu government's GO, the driver minimum wages for shop sack could be around 16,000. But the driver minimum wages for a chemical industry could be, I'm just giving you examples, it's not the actual amounts, could be 14,000. And the driver for some other minimum wages industry could be 18,000. But the work of a driver in any of the establishments is the same. He's going to be driving a car. That's it. So this is the kind of disparity that is there. It's even worse in Tamil Nadu. If you look at tailor for a ready-made garment industry is different, for a hosiery is different, and then there is something called as a home cotton or something where the bed linen and things. A third industry, if you look at it, is different. It's all tailors, but different rates of wages. So these kind of anomalies is what is tried to be fixed. So there is going to be a whole list of skill based on which you're going to. So if you take carpenter, it will be the same. You take a fitter, machinist. So it's going to be the same rates of minimum wages. The industry is not going to determine the rate of minimum wages. So just an example, if you look at security guard, the new level in the skill, in the right hand side, what you see is they've given it a serial number 283, the security guard, and then the appropriate government will now notify the rates of minimum wage for the security guard. So where he is going to provide security is going to be immaterial going forward. As on date, it is material. Where he provides the security, I'll again try to explain it once again later, time permitting. So bonus, gratuity can be forfeited. Similarly, can bonus be forfeited? Okay, then only for A, nobody for D. Hmm. Hmm. So you can forfeit. Many of you again here, conviction means it's a criminal act. There should be a criminal conviction. So again here, what they mean, this is again poor drafting. Conviction for sexual harassment means you have to be convicted not by a posh. Is it by posh or is it by a court? So is it going to happen in the same year? You terminate him today, you're going to pay bonus to him today. By this time, is he going to get convicted in a court? Your liability to pay bonus arises by November. By the time you will be able to get a conviction. So these are things which could have a little bit more of application of mind could have been there. Here an employer fails to pay an amount due to an employee under the code. What is the remedy available to the employee? Okay, I will hold the answer for now. We'll go with this more like you can to the next is this is even more. If an employer fails to pay an amount due to an employee under code, who can make an application? Any of the above. So anyone can make an application if there be a default. Three years? Sure. Do you know what is there under the payment of wages today? What is it under the minimum wages today? So yes, they have increased it to 3 years. So under payment of wages and minimum wages, it was much lesser. So this is slightly a favorable provision that has been brought about, where up to 3 years they can make a claim for any amounts due under the code on wages. So you again don't pay. So the question here is, you are an employer, you failed to pay something that the employee is entitled under the code on wages. He can make an application for the amount with the authority. So that we already saw in the earlier question. He can make, trade union can make, or the inspector can make saying employer has not paid. Please ask the employer to pay the amount. Apart from it, you can also seek a criminal prosecution. The code provides for it. All right. The question that I am asking here is, who can file it? Why am I asking this question? Why is this relevant today? As on date, under all the labor laws, whichever labor law you take, it is only the authority can launch a prosecution against an employer. So unless the Secretary of Labor of the concerned states approve, or if it is in the Factories Act, the dish has to approve. Apart from it, they cannot prosecute an employer. So may it be under payment of wages or minimum wages, the government is the only person who can prosecute an employer. Maybe I can, as an employee or a trade union, can give a complaint to the government. Government can then take it up. But no employee or trade union can directly file a criminal complaint till date. For the first time, Code on Wages enables this. Was this done with an intent or is it by mistake? Again, is something we need to see. Because this is going to create more havoc. So tomorrow, let's assume there is 2 rupees shortfall. 2 rupees. Employee can go and file against your managing director sitting abroad a criminal complaint, and a criminal court can ask him to come. Oh, you're sitting in Singapore, come attend the case for 2 rupees. So that's the possibility we are looking here. This is what was stopped all these years, wherein government could intervene, government could see what is happening, and then decide, okay, should I prosecute this employer or not? But today, this is given away to the employee, to a trade union. Let us assume, in fact, you have already paid the amount. Some trade union fellow has a grudge against you. He can straight go file a complaint. No questions asked. And the worst part is in criminal court, you have to appear in person. That's the worst part. All these days when these things come, all of you, you will not like the labor department. Oh, this ACL has come saying I have not paid payment of wages. This ACL has come saying I didn't pay this properly or that properly, or DCL came or whatever it is. Now they are going to be your friends. You know why? If they come and prosecute you, you can go and compound the offense. Your managing director doesn't need to go to court. Now labor department is more friendlier to you than your anybody else. Whereas these fellows can straight go to the criminal court. Whereas if it is labor department, they can compound it. So again, looking from that angle, this provision is going to be conflicting. Let's assume the same case I gave you, 2 rupees shortfall. 2 rupees shortfall is found by your labor inspector. Labor inspector issues a show cause notice. You go and say, yes, there is a shortfall of 2 rupees. You compound the offense with the labor department. But same offense, trade union goes and files a complaint, say 2 rupees before the criminal court. For the same offense, then can 2 parallel proceedings happen? The Act today provides for it. You may be able to go to the High Court and get it quashed. That's a different aspect. These are the lacunas that are there that we may need to get it addressed very soon when it comes to this code on wages. Otherwise, it's going to be that you're all going to be flooded with prosecution notice from criminal courts. Of course, I'll be glad about it. But then all your heads will just be rolling around saying what is happening. So thankfully, somewhere we need to try to get this resolved at the earliest. This is one of the extremely critical questions when it comes to the code on wages, an issue that we need to consider. Similarly, as I said, a trade union can also go to the Metropolitan Magistrate and file. Yes. So there is a difference. I am not saying just the liability to pay. The liability today is to pay it on time. But then it's also going to pose challenges. You think this is workable? Many of your companies will have a 30-day credit period, 60-day credit period. What happens to that? Forget that. Let's not even go into that. You will want them to show that they have paid PF, that they have paid ESI. When will he be able to do it? 21st will be the earliest because ESI payment is on 21st. So he has time till 21st. So for last November's payment, he will give you the bill maybe on 22nd of December. So, but now he can say, no, pay it by 5th. So this is again going to pose certain practical difficulties. So how this time limit is going to be fixed? If your contract says a 30-day, 60-day credit limit, but whereas the statute is going to say paid within 5 days and 7 days. So how do you reconcile this? This is again an issue that may crop up very soon. So rule 55 on the code on wages says that when a contractor is there, the employer should ensure that it is paid so that he pays it within the days. So 10th or 7th or whatever, by some date if he has to pay it, you should ensure that you make your payment. So is this going to be a challenge again, especially for contract labor? Under the Payment of Bonus Act, does anybody here feel that the Bonus Act cast an obligation on you with regard to your contractor? The Bonus Act doesn't. Payment of Bonus Act doesn't cast an obligation on a principal employer for bonus. You know why? Because the bonus depends on the profit or loss of the contractor, not your establishment. That is why the Bonus Act alone doesn't cast that obligation. Payment of wages does, minimum wages does, gratuity does. Bonus never does it because you don't know. He is not going to give his balance sheets to you, his profit and loss to you. So there's no liability cast on you. But without appreciating that, here the code says you should ensure a minimum bonus is paid to the contract labor by the contractor, and that is the obligation of the principal employer. And whenever there is a written complaint in this regard, you should ensure that it is complied with. Eight hours. Okay. Where do you think the challenge comes for this now? 5-day week, 4-day week. There's so much of news items going on in social media saying up to 12-hour shift you can have and all those things. I'm sure Mr. Jayaprakash would have touched on the working hours under the OSH code. I'm also sure at least he would have touched or one of you would have asked. What happens to the Tamil Nadu Shops and Establishments Act? You, for instance, if you look at ITES, there is exemption in the Shops Act. What happens to that now? Have you seen any software company paying overtime or having overtime hours? All of that is gone. I don't know how many of them realize what has happened. Because the OSH code covers even establishments. It is not only factories. This is again a blunder. It's a legislative drafting blunder. Under OSH code, they only wanted to bring factories, in fact, but because Contract Labor Act came in, and Contract Labor Act also brings in establishments, they brought in a general term of establishment, and therefore everybody is brought in. And therefore now you have two. One, you have the OSH code, which defines as to the leave, working hours, etc. And then you also have your Tamil Nadu Shops and Establishments Act. Both are going to operate. Some you will need to take from OSH code, some you will need to take from Shops Act. So these are going to be really challenging things that are going to come forward. But that's how the law is, because the new law will prevail over the old law. So if there is conflict between working hours and leave benefits, then the new law will prevail. But at the same time, your complaints under Shops Act will also continue because Shops Act has not been subsumed or been rescinded by any of the courts. So the state Shops Act will continue. But if there is a provision for, let's assume, leave in the code on wages, you need to follow leave there, working hours from there. But so much is being said that you can do 12 hours. I don't understand from where people are getting this. The code only says 8 hours. And thereafter, whatever it is going to be OT. For that, power is given to the state government. You can have a spread over up to 15, up to 125 hours. All that is given to the state. But a normal working hour cannot be more than 8 hours in a day. So all the 5-day working establishments or factories or industrial establishments are going to have this challenge going forward with the code. Wage slips become mandatory. I think it's already there. So this I think I already addressed to you, saying that from 2111 you will need to ensure that you comply with the codes. So anybody today resigns, you will need to pay in terms of the codes. The 2-day, should I settle everything within 2 days? Yes, what is your answer? I would like answers. Only the wages. Okay. So there is no liquid requirement for gratuity. All that I don't think should come within the definition of wages. Again, so we go back to what is wages. Leave encashment is not wages. So therefore that will not come, bonus will not come, gratuity will not come. That is not what they mean. Again, this also to some extent is, let's assume what the reason why this was initially found in payment of wages is that there was a notice period. So as an employer, let me assume I tell you I want to leave. I am leaving your organization on 25th of December, I want to leave. So you already have notice. So if once you have the notice, process it on 27th and pay. But today when organizations are larger, you have an outsourced vendor through whom you run a payroll. You may do it in a systematic manner on 30th or 31st or the last working day. Or different organizations have different structures. Is this mandated? Especially when we have moved from cash and currency to all bank transfers. And there is going to be proof of payment. This kind of 2 days you have to pay. These are again were not required. There is a pay cycle you have fixed a month. And in that month you are going to do it when you do for others. Therefore, this was not required. See, a lot of places where the government could have looked into this when they were drafting and could have corrected these. I already touched on this. Compounding is available, but the first time, if you're going to keep repeating, there's no compounding. So for the first time when you do it, you can compound an offense. So the amounts have increased to keep up with time. Please see what comes within when you repeat. It's all getting doubled. So this is a question may look, see, for each one of you this could be different. For most of them, from a private sector to private sector, no issues. But if you are a private sector, your employees go and work in central government, or you are a PSU yourself, and then some security guard comes in, housekeeping comes in. That's where this question is. For those people, that's where this is the issues for this. Today, the minimum wages is not dictated by where you work. The minimum wages is dictated by, so this is the example I technically give. So you have a security guard. The security guard is employed by whom? By the security agency. For the security agency, Tamil Nadu government has fixed a rate. And the appropriate government for the security agency, which is only a Tamil Nadu shops and establishments covered agency, therefore the rate fixed by Tamil Nadu government alone will be applicable. So whether I send him to work in a factory or a bank is central government, or a ready-made garment or a manufacturer or the airport, the rates of minimum wages will not change. I need to follow what is prescribed for the security guard by Tamil Nadu government. So even if I send first to 8 to the airport, 9 to 16 to hospital, the rate will remain the same. Where he works is immaterial. But that is now going to change. Why does it change? The definition of appropriate government changes. And in that they have included this, including establishment of contractors. This again you will find even in the IR code, this insertion. It doesn't make sense, but this insertion has been made even under the IR code. So because of this, what happens? The same security guard, if he goes to work in a factory or a ready-made garment factory or something which is on the top, then he will get rates of minimum wages fixed by the state government. But if he goes to a bank or airport, then he gets the rates fixed by the central government. So this is going to be a significant change, especially in public sector. And if you are going to be sending your employees to work for a public sector or a central government. So this is all going to be changing now. So the logic also, if you look at it, there's just no logic. That's why I wanted to put this to. So if I ask the security guard to work from 1st to 8th in an airport, he will get a higher salary that is being given by the central government. But 9 to 16, when he goes to the hospital, he'll get the state government salary. So this logic again the worker should not be denied wages based on the place he works. He's going to do the same security work wherever he works. So that is being lost here. The code brings in a web-based inspection scheme. And the central rules, again, they're going to bring, as I said, different skill level based. So enforcement comes to the inspector cum facilitators. They will be enforcing the codes. So now we come to this definition of wages. Before that, let me just run a few slides. I'm not going to answer these. I just want you to read it. Don't even bother to answer for now. Just read through and then I will run through the slides. What is the percentage that it exceeds? Next question. What happens if more than 50% is there? Okay. Or maybe I'll come back to these questions once again. How many of you think that you need to now restructure your salary and ensure that your basic wages is 50%? Yes, you need to. Correct? Is that what the code wants? The uniform definition of wages, now you should ensure your basic wages is 50% or basic plus DA is 50%. Yes, no? I hear quite a few S's actually. Okay, let me try to simplify this. I will run through. This is, I think, should make it. This is the basket. What is this basket? This basket is your wage slip. Just take your wage slip to be this basket. So I call it basket A. Okay. So what goes into this basket A? All remunerations, including then what are you required to do? This is step 1. So step 1, you put everything into a basket. Are we clear up to this? What do we do next? Then we have basket A with all remuneration. From this, what do we remove? You remove whatever is given in A to I. Correct? I repeat again. You have basket A which has all remuneration and you remove exclusion A to I. What do you do with it? You put it in basket B. This is step 2. Pausing here for a minute. You have special allowance. What do you do with special allowance? If your company has special allowance, where does it stay? A, B, A, B. If it is a monthly pay, it will stay in A is one of the answers. Okay. I will slightly change it now. If the special allowance is paid by a settlement, B. So you need to be careful about it. What I am trying to bring it to your kind attention here is everything goes into A. You remove out only the specific exclusions given in A to I. All the remaining amounts, where do they stay? A. Okay. So this is step 2. Then we move to step 3. Sorry. So if A is heavier, please look at it as a scale. When you hold a weighing scale, tarasa podumbodhu heavier goes down, right? So that's what we have done here also, the heavier part. So let's assume this basket A has 60%. It is heavier. What will you now take as wages? 60 or 50? My gosh, so much clarity here. You take 60%. You don't take 50%. So that is how you do it. So basket A is heavier, then you don't do anything else. Basket A is taken up. What happens if it's the other way around? You need to increase it. You need to. So what do you do with it? How do you move it? Okay, all of you have got it right. Just 1 minute, please. So you have A, which is a lighter. So now A is 40%. B is 60%. You need to move at least 10%. Yes, how do you move it? You need to then put basic wages more. You don't need to do anything with your pay structure. Please get me there. You don't need to do anything with your pay structure. But when you calculate gratuity, you will notionally take 50%. So if somebody's salary is 1 lakh, 60%, 60,000 is allowances. You will take 50,000 as wages and calculate gratuity. Same applies to anything. You don't need to restructure and ensure that, oh, I should ensure balancing. That is not what the law requires you. You should ensure you take 50% for calculation, your complaint. Is it so confusing? I hear too much of murmuring. Hello? So, going back, I have all your attention. So, the proviso which requires the 50%, first and foremost, it will kick in only when? When will you need to do this balancing act? Only when B is more, not otherwise. So, two key things, or rather I'll put as 3. You need to ensure your basket A is more, or rather not ensure, if your basket A is more than 50, you will be taking your basket A. You don't need to do anything. If your basket B is going to be more than 50, then you will notionally take 50% and equalize it. It's a notional thing that you need to do. So what does the section require is bare minimum 50% should be there. That's all it requires. But it doesn't mean you can stop at 50. It can go to 60, 70, 80. So the bare minimum is 50. That's all is the scope of the section. So you need to see how to do the balancing act. So now we'll put this into action and see what happens. So which is going to be your today your minimum wages. We'll go back to Minimum Wages Act. Today let's assume that your minimum wages for shops and establishment is 16,000, right? Some government gives you basic of 10,000, DA of 6,000. Let's assume minimum wages is 16,000 today. The 16,000 you can split, or the example is 12. So let's stick to 12. So you can do 9,000, 3,000, 12,000. This is what the government has done. Or you could split it as HRA. If I ask any one of you whether you're doing it, you will all say, no, we don't do this. Maybe true. But if I ask, is your contractors doing this? What will you say? I think I'll get a unanimous yes there. So your contract labor cost is going to increase. So your contract laborers cannot split minimum wages going forward. Why? Because as per the definition, basic and DA has to be what it is prescribed. Your HRA cannot be there. These allowances cannot be there. So you have to pay, if the government says 16,000 is minimum wages, you cannot split it. So the entire amount will need to be paid as either basic or basic and DA. Unless the government itself splits and announces that HRA is going to be 3,000. Why I am suggesting is next you can start lobbying with the government for that also. So if the government does it, then it is fine. But if the government says basic is 10 and DA is 16, you cannot split. But if the government says basic is 10, DA is 4,000 and 2,000 of HRA, then it is fine. So this is going to be the next challenge. Any one of you who thinks that the new codes will not have an impact on gratuity of your company here? Anybody saying it will not impact? And you know why the impact, where the impact is going to be? No. All of you sitting here. The white collars is where the impact is going to be much more. Not with the blue collar. So all you professionals and a level above, you are all going to cost your company more by gratuity. So if you look at technically when you go up the ladder, so let's assume a 30 lakh CTC. What do you think will be your basic? 30%? I don't see crossing 40% even in any company. 50%? Okay, good, great. So as you go up, the normal tendency is to keep the basic lower, your DA lower. So it's all going to impact going forward. So this is an example where I've given of a 1,10,000. So you take basic wages of 40,000. This is what your gratuity is going to be. Any guesses how much it would be with the new wages, new code? So this is the impact. I have put in 50% as well there. Because many tend to think it's going to be 50%. It is not 50%. That's the reason why I put 55,000 there. For actual calculation, what you will be taking is 40 and 20, it is 60. So the calculation, if you see the jump, it is a significant jump from 2,30,000 to 3,17,000. Over time, you think you will save or you will pay more? Pay more? Are you sure? 2 times today also you should be paying. If you're not paying today, then you're already violating. The question is on wages. So if you look at the most, I would put it this way, I don't know if it's right on my part to say it. Most of our traditional Indian companies reckon only basic and DA for OT. But the benevolent MNCs, they take gross. So it depends on what you are currently taking. So if you are currently taking gross, if you are currently taking gross for calculation of overtime wages, then you may save. This is law. Practically, will you be able to do it? Your employees are not going to allow you to do it. They'll still want you to maintain the 28,500. They are not going to accept saying the code on wages is come, make it 50%. They'll say, I will not do OT. My consent is required under the OSH code. I will stop giving consent. Either you agree for 28,500 or I will not give consent. This is what is going to happen. But then in law, it is sufficient if you reckon, and therefore if you are a company which is currently taking gross for OT calculation, you get to save. Retrenchment and closure, what happens? Dead silence. You pay more or you pay less? More? Okay, that seems to be a unanimous answer of you're going to pay more. So again, now after seeing this, are you going to still? So HRA and conveyance is excluded from wages. So it can go down, right? Again, all I'm saying is not going to happen practically, but I'm just telling you legally what can happen. Provident fund I'm not touching. I'll leave it to Kavita there to go into it. And also today I don't know the position in this, but it's my earlier slide. So both PF and ESI I'm not touching. So there's something on code on wages that I will just. So what do you do next as far as code on wages is concerned? You don't need to restructure your salary. There seems to be at least the component structuring, but there is a possibility of reducing your liability. So that you can work on and it could happen. How you do it is a question. Especially as I said, not with your blue collars, but with the higher up executives, what you do is something that you may need to look at. Because if somebody is to even retire or resign today, the liability that is going to come out to your companies is going to be huge. The provisions you make for earned leave, the provisions you make for gratuity is going to hit your balance sheets on 31st March. If you want to reduce it, there are ways to do it. You would need to restructure on that aspect. So again, earned leave is concerned whether you take basic and DA or you take the gross, all this is going to be there. This is also going to have an impact on bonus. My slides on bonus and ESA and things are missing here for some reason, but if we take bonus, for instance, today we say 21,000. Some companies again take only basic DA to reckon whether they come in or not. Some companies take gross for it. Again, there is different thought process that goes into it. But going forward in the payment of bonus as well. So a person drawing even 42,000 could come inside if the ceiling is 21,000. There's no ceiling today, but I'm saying if a ceiling comes in, person up to even 42,000 could be eligible. What happens in ESA? Today my salary is 30,000. Will I come within the definition of an employee under ESI? So same basket A, basket B, you take it, if 18,000 I will come. But there's also a plus to it. What is the plus to it? Let's assume today you have covered your employees under the ESA Act. let's assume the total salary of your employee today is 20,000. And for that employee, you're paying contribution. On what do you pay on the contribution on the entire 20,000, right? If the 20,000 has HRA, what happens going forward? So excluded. So 4,000 of HRA is there. Instead of 20,000, you will pay ESI only on 16,000. So just as much as more employees could come within the purview of ESI Act, the contribution that you may be required to pay could also come down. So the definition of this wages is going to have an impact in your OSH code, in your IR code, and in your social security code. It's not just in the code on wages. It's a uniform definition. Again, as I said, please be careful where the word used is worker, where the word used is employee, and see the application of the code to each of these. So that is how you will be able to. It's going to be a big learning experience for all of us. There are plenty of gray areas. There is already litigation started. I don't know if you've all seen on the IR code, because all the labor codes have stopped functioning. Existing cases are there. So cases already been filed in Delhi. Case was filed yesterday in Madras, saying what happens to the labor codes as on date, because the transitioning provisions haven't happened. While now on this subject, today, what are the minimum wages you need to comply? Today, let's take your own industry, whichever industry you are. What do you think is the minimum wage you will need to comply? 18,000, 15,000? Yes? Okay, 1 minute. Whoever said 18,000, which is the industry? Okay, manufacturing, general engineering. So, from where is that notification published? Under the Minimum Wages Act? Yes? Is the Minimum Wages Act today in force? So, as of 2211, is the Minimum Wages Act there? Is the GO then there? So, as on today, there's no minimum wages. Nobody can question you guys. These transitioning provisions have been missed out. The government has to frame rules, then they have to form the committee for fixation, and so for the next 6 months or 8 months, there could be no minimum wages. None of you can be prosecuted for anything under any of the old laws. At the same time, you can take advantage and say, I have 300 plus workers, less than 300, 100 plus, but less than 300 and retrench. See the kind of advantage government has given you. So if you have like 200 workers, you can say, I'm using the code on IR. I don't need to seek permission. I will retrench. And that too at what? Lesser wages. So this is the kind of dichotomy that has come in by the government. Suddenly, there was too much of opposition from all sides. So they didn't know what to do, and they thought, okay, suddenly we will just put it on 21st and bring it. And that has caused a lot of issues. At least they should have had the rules ready, which they did. For some reason, they're not publishing the rules. They're going to again republish the same rules, then 45 days to get comments, and then they are going to publish the rules, and they say it's going to be April. So this is going to cause a lot of issues, and you know who's the happiest person in this room for that. So last bit I will leave with all of you is to, there's a lot of changes happen. That could have been better. The courts could have been better. There could have been better application of mine, but that's not been there. But please don't look at any provision of any code with your same thought process of what was there in the earlier acts. You will need to unlearn and then learn. Please look at it in the perspective of the code, whichever code concern it is. Unless you do that, there is bound to be mistakes that we will commit. So to avoid it, first, forget all your old codes, forget everything. Forget your old acts, sorry. And thereafter, try to come about with this and see how the code is, what is the word used, and what is the purpose of each code. And from there, I think you should be able to handle it. Thank you. I think I have 5 more minutes.
I think it's been a fabulous session. A lot of scenarios also worked out practically there. We have a few questions. We will take about 3, 4 of them before we go to the next session. Question. So these are the questions that are coming for you.
IR code.
Let's be a little silent so that we can hear to what he's saying. Yeah.
I hope I have answered this already, but if I have not, you're free to email me and avail my professional services. PF, again, I'm touching into the next subject, but one thing that is that you could restrict your PF to 15,000 or where you are today. You don't need to increase your PF. Of course, PF hasn't come into force, but even if it comes into force, I don't think you need to go beyond the ceiling. And the government today is not in a position to service even at 15,000. They're finding it difficult. So the interest rates are going down. So the possibility of the PF ceiling increasing is going to be remote. Like bonus, they may increase the ceiling for eligibility to come in. So up to 30,000, somebody may come in, but the contribution, I think they'll still mostly retain it at 15. That seems to be the thought process. Government is just not able to service. It's thankfully because they have around 55,000 crores surplus that they are able to even handle this. But so the 15,000 ceiling being increased, I think is a very remote possibility. So you could continue maybe on that. As I said, minimum wages is not there today. Floor wages, as I said, it's nothing to do with any one of you here. It's more an equal pay overtime. Overtime again, as it depends on whether you're going to pay on gross or how you do it. Gender parity rules, I think as of now, in private, I don't see much of that happening on a gender basis. So I quite not able to answer this question at the moment, but then you would need to ensure compliance with the rules of each state. This is one more part I thought. There's a lot of information spread in news media, social media. 1 year you need to pay gratuity. 1 year you need to pay gratuity only for FTCs, not for your regular employees. Regular employees 5-year remains. There is no change in that. And I don't know about it, but certainly a delight for lawyers. The CGITs, everything is going to go out. There is only going to be tribunal with 2 judges. No more labor courts. Tribunals with 2 judges. And our experience with wherever the tribunals have been, 1 judge will retire. There will be only 1 judge. So no cases will be conducted with this 2 judges formula. It never works. Unfortunately, despite experience, government once again brings in this 2 judges formula into it. This is all again into IR code. Yes, standing orders will be applicable to shops and establishments. There is one aspect, I'm not sure if Mr. Ravindran touched upon it. The transfer clause in the standing orders. No. So the certified standing orders, whether you need to get it recertified or not, is something that many have been looking into. So the question that comes is, if you already have a certified standing order, if that certified standing order and the model are going to be pari materia the same, then you can use your old certified standing orders. That's what the law is. And who is going to write the certified standing orders? Only central government. State government is not going to write. The central government has already published draft standing orders. There are 2 things you will find in it. Fixed term employment, that is to your advantage. And then for the first time in anywhere, they brought in a clause regarding transfer. Till date, transfer is governed only by appointment orders. Now, certified standing orders is going to be brought in your transfer is going to be brought in your standing orders. Does any one of your standing orders have transfer clause? Therefore, all your standing orders are repugnant. You have a standing order with transfer within the factory. But then it could be multiple factories within Tamil Nadu. I'm quite surprised. I don't want to ask you how you got it. So, most of your standing orders, except for such exceptions, would not be valid. So, to answer that question, whether the model standing order, yes, it's going to be applicable even for shops and establishment. OT is no more on basic and DA, it's going to be not gross, wages. Okay, thank you.
Thank you, sir. Ladies and gentlemen, let's give him a big round of applause. Great, great clarity, sir. Thank you so much for your time. I know you've been doing this since morning now. I don't know, second or third session today, but good. Thank you. May I request Group Captain Vijay and Mr. Matthew to come on to the dais. So please accept a small memento from NIPM and MMA for doing this for us this evening. I think we should have a day-long session with each of the speakers that came today. Thank you. So we are moving to the last special session of the day, and after this we have a panel discussion. This last special session is on a code on social security. And to facilitate this session, we have Ms. Kavita Jagadishan, Director at Deloitte. May I request Ms. Kavita to come and take the place on the dais, please. Hello, ma'am. How are you? Yes, ma'am. May I have the AV of Ms. Kavita, please?
Ms. Kavita Jagdishan, Director at Deloitte Touch Komatsu India LLP, is a chartered accountant specializing in global employer services with deep expertise in mobility, payroll design, and employer-employee frameworks. Passionate about communication and process excellence, Ms. Kavita focuses on creating value-driven relationships and leveraging technology as a strategic enabler. Ms. Kavita co-leads APAC Global Payroll Operate Market Activation and is known for her belief in agility and resilience as guiding principles.
Thank you so much, ma'am, for sparing your valuable time and being here. May I request Ms. Kavita to take the session forward, please.
Hello everyone. So the first punishment is putting together our LinkedIn profile and making us sit in front of the hall and seeing our reaction by the entire crowd. This is the first time I'm feeling this highest degree of embarrassment before even starting the session. Thank you for making me feel that, sirs. Because we would have written something at that post in that way and how we'll have to start when we are getting into a LinkedIn profile. But anyways, it's a good experience. I try to control how much of the embarrassment I'm having it. The second one, before I even start, I should know how many of us are quite familiar with Tamil movies and comedies and all? Quite a few of us, right? So there is one movie where Parthiban and Vadivellu would be there, and there is a board that will talk about Ingu Meengal Virkappadum. And with every discussion, they say Ingu will go off, Meengal will go off, then there will be only board. That is exactly what my session is going to be today. Right? So I was wondering, okay, I was in fact asking Matthew sir and Captain, now code on wages, if Anand is touching, it is very difficult for him to touch without gratuity. Then now tell me what I'll do. And he said, no ma'am, better you do. Then I thought, okay. And I was hearing all the degree of sound and the hesitation when he was giving a different perspective to wages, when all our brains were starting to reconcile with the morning sessions. Then I felt, okay, then I have some more masala to add for the fourth session. Right? So you would have heard from the morning from all the lawyers, legal practitioners. With due respect to them, here I am to present a chartered accountant's perspective for the Code on Social Security and the wage definition. Now, at the outset, Thank you so much. I have never seen a full packed session, and that too from the morning. You have been there attending this masterclass with full of interest, and I was peeping every time behind, and that's definitely a round of applause from my side. There was not even a single tiring look I could see from the time I've entered. The way you were responding, now I'm finding it super enthusiastic to give my perspective and more and to add more flavor to whatever has been done from the morning. Now, basically, right, I'm not a section or a clause proviso person. I try to understand the concept so that it is easy for us to implement. So now we can say what is code on social security. I think from the morning they would have touched upon how this labor codes have been evolved. All those background flashback would have been touched upon, right? So let me deep dive into the COSs first. So initially we would have thought code on social security is something to consolidate. If you could recall, in 2019, when the first draft was all submitted, there was a committee that went through it, and the initial preamble to this legislation is to say to consolidate social security for employees. Then that is when they had lot of deliberations from different representations from the companies, and then they have made it this way. So it is consolidate the laws. And what is the goal? The goal is to extend social security to all employees and workers. Now the first confusion started. If it is extending social security, which part of the social security are they going to extend? If it is employees, then who are the workers? Are the workers the employees? And then either an organized or unorganized sector. So the intention is very clear. So any establishment, any worker, any employee, our first check is to have this whether the social security benefit is extended to them or not. So that's the intention of the legislation. If we are going to approach the entire 30-40 minutes, what I'm going to have in the next view, it will be easy for us to appreciate how this has come. And I'm not very aggressive or ambitious like how the previous speaker is. So I duly respect the government for reasons known to you. I don't want to be anything anti-government when I'm presenting here. If at all some of my views are giving you that impression, I ask an open apology upfront. So this is nothing to do against the government or against its propositions. But the entire session, we will see how we can leverage on the clauses that have been provided and how we can implement. Now, what are the legislations covered? I've just put this timeline chart. It was just designed automatically because from 1923 till 2008, there were so many legislations that were there that were talking about social security to employees. So here they have tried to consolidate everything. Is that being in one chapter? No, there are multiple chapters within the Code on Social Security, but these are the legislations that are being covered under Code on Social Security. Actually, this has received presidential assent in 2020, September 29, 2020, and made effective November 21, 2025. And in that, they have specifically removed EPF under the subsumed part. So rest of the legislations are subsumed by Code on Social Security, and EPFO is still not repealed. Now you know why I said, Anand said Kavita will take care of PF. What is there to take care of PF? I do not know, because the existing provisions will continue. Right. Now, how are these arranged? This is more of academic interest. This is how the chapters read, and I'm not going to take you through chapter by chapter, but just wanted to tell you that the entire code, based on each of the legislation that is subsumed, it is given as a chapter. That's how we are going to approach this now. Now, for this Code on Social Security, if you are really watching pib.gov.in, that press release website, where our first government announcement has come, and every day we have been getting a lot of press releases. And if you find time, even before you approach a consultant like me or a legal practitioner outside, you can go through background or fact sheets that are published by the government there. And that puts in the reason and how this has to be applied. All those examples would be there in the PIB website, the government website itself. So they say for Code on Social Security is pro-employee, pro-women employee, and pro-growth. Okay, now on employees, so they have listed few points. I'm just going to read that out now, and then we'll take a deep dive a little later. So they say for FTEs, fixed term employees, gratuity is extended. That's a key feature. See, before November 21, 2025, the entire issue was about if PF is also impacted by the wage definition, my take home will go for a toss. So that means ideally, I would not be standing here today. I would have been in some other legal office asking them to file a petition on behalf of me, because my take home will also get impacted, right? But now, safe and strategically, PF Act is not repealed, so we need not worry. Even otherwise also, for your information, in Code on Social Security, the legislation itself says for PF and ESI, employees are those whose wages does not exceed the notified limit. So all the trauma that we have been having before is of no relevance at all. Because the act clearly says if the salary, for example, if the wage is 15 for PF, if it is more than that, then we are not even covered. So not because just they are not repealed or not repealed. Even otherwise also PF, there is no impact because 15,000 ceiling will protect most of us, right? Where the wage is less than 15,000, that is where the challenge could be. New concepts are introduced, gig and platform workers. See, I've told you, right, from 1923, the legislation is evolving. And so we see different model of workforces. So they want to they are trying to bring everybody into the ambit. Universal coverage, yes. Definition of wages. Give me 5-10 minutes, I'll come into that slide and let me see how many of us giving a different reaction now. And family definition is enhanced to cover in-laws for women employee. I still have a question on that. Why in-laws for men employees are still not covered? Because for a single child who is a daughter, when I get married and then go for with my husband, who will take care of my mother, my father? Is still an open question. Maybe if you have an answer, please do drop in a line later. Next is on accident coverage. See, under the existing provisions, or I can say erstwhile provisions, in employees' compensation legislation, the accident that is happening in the commute to the office is not covered. Okay, now they have included that as well. So these are the items which I wish should not be even triggered. But basically, being HR people, if you come across those situation where if an accident happens from home to the office at the reasonable route, because we know how stretched the route could be, then this could still be considered for employees' compensation benefit. Women employees, I will touch during the maternity benefit slide, and overall growth, we will go through that in a while. So this is the snapshot of what we are going to cover in the next 30-40 minutes, right? And this is purely literature. Okay, that's what I said, right? So I'm left with nothing other than to put in some literature to us. So I have to fill in the 45 minutes. So one is National Social Security Board is now created. If you observe the government's legislations throughout, whatever is coming in for, they would set up one board, two committees with state and national. These are all some standard templates that are coming in. So even in social security is not an exception. So we have National Social Security Board and we'll have a Social Security Fund. The reason is the benefits that are going to gig and platform workers will be routed through this fund. So for any positions that are coming through the other sections of the legislation will be governed by this Social Security Fund. And we have Unorganized Workers Social Security Board and state. See, this is simple logic. If it is unorganized sector, mechanics by the central government would be a little bit difficult. So it has to be through state government, as simple as such. And obviously, there are additional functions that may come for account of these boards and these committees. Now, there are multiple definitions. I'm not touching these at this point. One is on the employee, which I've already covered. But these are the areas where we can speak now. Right? One is gig worker. Gig worker is more like a freelancer, if we can call. The one person who can come and then drop into your office for a particular work and then drop out. Say you have a testing issue, not assigning them full time, but just coming in there for that particular project and leaving, like a freelancer would be a gig worker. And they don't have an employer-employee relationship. So obviously they are out of all these social security governance model. But now they are trying to bring benefits to these gig workers also. Platform workers, Swiggy, Zomato, Blinkit, Zepto. So except for that, we collect from them. They don't have whatever we add. I do not know whether we pay additional things or not, but we make it a habit at least to ask for water from them. Now the government is trying to protect them through some social security benefit. Last but not the least is our fixed term employment. So fixed term employment, there are multiple questions that are coming to us. Say in an organization, if the employment contract doesn't have an end period, if it is provided as 1 year and 2 year, does it alone quantify that person as undergoing fixed term employment? This is one fundamental question. Or there is a retainer who is working in an organization. Is he or she a fixed term employee? So we will have to see and understand if the same set of benefits that are provided to a regular employee are also provided to a fixed term employee. And if the job allocation is also defined, very commonly project based hiring, maybe during festival season for 6 months, we may hire a person to support if you go textile companies. And now say, for example, during compliance season, many practitioners do that. During recruitment, investment proof verification, you hire some people for 3 months, 6 months for fixed term contractors. Those are fixed term employees. And now they are, because it's fixed period, it's fixed term employees. Now, the next one are definitions from unorganized workers. I'm not dwelling much into it. Home-based worker, say for example, the project is given, which is quite common in rural or semi-urban or even work from home culture, wherever it is possible, they are home-based worker. Self-employed worker is a so-called entrepreneur. Entrepreneurs, don't take me wrong. So all those, the limits would be prescribed where the amount is not so huge, they can still be considered self-employed worker. Wage worker or typically the workers and unorganized sector who are getting in for wages. Now EPF, since he said I have to touch, let me touch. There are no changes in PF. One point that I would like to highlight is under this code, see existing provisions, voluntary coverage is possible, right? So employees will ask for, many startup companies we have seen, even if the employee count is 5 or 6, the employees ask for it, and we don't start an organization with a view of not expanding, correct? Under this code, there is a voluntary opt-out mechanism is also going to come, which is actually not publicized in media. I ain't very sure the reason, but this is very much available in the Act itself. It is not even in the rules, it's in the Act that says that voluntarily, subject to the conditions and to the request that is made to the Central Provident Fund Board, the organization can also opt out of Provident Fund. So this is one welcome one, because when companies were having higher salary slab where I see a trend, I'm not stereotyping it, but Gen Zs, in most of the clients where we speak, they see they are not even opting for Provident Fund. They say, I need a better take home so that I can invest better in the market rather than somebody investing for me in other funds. So having said this, there could be rules. When the rules are coming out, we can wait and watch for the mechanism, the approval point application for coming out. Now, the other one, which I would also like to cover is, in under existing provisions, if you have trust and it is already exempted from PF, it continues in the later one. Just because it's becoming a monologue, I just want to know by show of hands, how many of your organizations have PF trust? Good, great, PF trust, excellent. Okay, I know now RPSCs will start to convince you more to get that converted into PF. So it's more for a better management as well. So under these provisions will still continue under the existing code. Now, what could be the impact under Provident Fund? So in your organizations, if you have expat employees or foreigners who are working, so again, by show of hands, any organization where you have mobile employees, I mean foreigners working in your organization, only one. Great. Super. Fantastic. So normally if you see for foreigners, when we submit visa applications, it's 1 year, 2 year contract. And we don't provide for gratuity. See, already they are tax equalized, already social security equalized, every benefit is going through them. But now for all these mobile employees, gratuity will be applicable because they are considered as fixed term employees. Okay. So this may cause an additional outflow to an organization. So whenever you are having foreign nationals being deployed, there is a fixed term employee trigger will come in. ESI, not much because it's the same one. If the procedures or in the limits are met, it's again the same. This is out and out for my self-satisfaction. I have called out this definition onto the board. So if someone has an answer, how come a parents of a woman employee can be protected? Please do let me know. Or when the rules are coming in, please do write the recommendations to the government that the parents of women employee should also be covered. We'll go for gratuity. Right. So now gratuity, again, we don't have threshold, right? That is where the question is. We don't have threshold for gratuity, leave encashment. So that is the topic that's now talked about. Now, when I talk about gratuity, I should definitely touch upon wages. Rest of the things, there is no change. See, you must have also heard in wages, I'm not sure Anand has touched it or not. Within 2 working days, full and final settlement will have to be done. Imagine a situation where we don't even recover any, we have some lot of money to recover from the employee. How can we do a full and final settlement in 2 days? And now what is covered under full and final settlement? There is still, it's a question that is to be answered. But now, as of now, my understanding and my view is that since code specifically says gratuity 30 days limit is available, let's have 30 days assumed and we'll keep it out of the 2 days limit. Now for gratuity, I know I am differing from Anand's view. Anand is not here. Okay, fine. So, and I was telling Mr. Rajendran that again, some more fun is going to be there. But let me take it a clear example, okay? Let's read the definition, what is provided in that. It says everything is part of wages. So my entire amount. Now let me assume I don't wear a basket and all there in the slide, but let's visualize we have one green basket which has all components that is put. put in, right? Whatever is coming in the employment contract, it is there already. Now, from that, each and every component will have to be analyzed to see if this fall under the exclusions bucket. This is how the definition reads. Why are we complicating? I'm not very sure of. Right. So with due respect to all the speakers again, let's read by the definition. It says all remuneration by whatever name it is called, including basic DA and retaining allowance. It's just more a clarificatory nature. So if 100 is my all the components available in my employment contract, that 100 will be in my green barrel. Okay, because we are dealing with big shots, so I'm adding a green barrel. That much amount we have. Now each and every component I analyze and I see whether it is falling under this box. Specified exclusion, HRA excluded. I will pull it out and put it under my red basket, which is an red barrel, which is an exclusion barrel. Now, this is how we are going to start our analysis with. So now then I will compare if my red barrel is more than 50% or not. So I have a fundamental conflict when in the previous discussion, I think many of you have agreed also that if the remuneration and 50% is already covered as wage, then we don't have a challenge. I have a different answer to it. Now let's take this example, right? Or before that, let me go to a easy one. Okay, let me take this one. Okay, so you've been attending 3 sessions, right? Let's try. So we have basic, let's go scenario A. I would need answer only from that side so that we know what is coming and out. Basic is 30, HRA 20, special allowance is 50. So under PF, presently if it's more than 15,000, let's assume it's all more than 15,000 because it's there 30. So what would be the base for PF? 30,000. Basic, we will contribute on that. For ESI, the total allowances we take 100. Gratuity again, we take 30, right? Similarly for rest of the scenarios. So this is the numbers that we are coming in. Now what could be there for code on social security? So I have my total of 100 and under code on social security or under labor codes, what would be my wage? Maybe for the first scenario, anyone would like to have a try? Someone said 80? Okay, 80. Perfect. The second one, scenario B, if you could try. Scenario B is also 80. Because basic is already. How many of us are saying 50? 50. Super. Very good. Okay. Now scenario C, 40 and 60. Prachane and I'll give everything in HRA. 50. Not 40, is it? Sure. Okay. Now scenario D. So scenario D, we are all right. So it's 50. Scenario C is also right. 50. The challenge starts in A and B. Okay, so from what I heard from the previous session is that 100 into 50, if I put 50, that's a bare minimum threshold. Unfortunately, my legislator has not put it that way in the definition. Right? So the first one is I should add everything, which is 30, 20 and 50. I will pull out only the HRA, which is 20. That means 30 plus 50, 80 will be my base. So because you have 50, now in the second scenario, I have heard from people who have said, Kavita, ni romba confused pandra. I will keep my basic as 50. What is the problem now? Everything solved? No. Government didn't say basic has to be 50. See, as of now, this is the position. Huh? Tomorrow, if there is a press release coming in, please don't quote me that I've given a wrong answer. So right now in the Code on Social Security and with all the interpretation, it says all remuneration should be considered except for the exclusions. Now, basic is 50. Am I compliant? The answer is no. Because in a green barrel, I am putting all the 100. I'm only removing 20, right? So 80 is still my base. That's my wage. Now, I have also heard previous speaker and many of you said that we need not do anything about it once it's let the structure remain. I have a fundamental question. See, we know the concepts well, but we are still dependent on our payroll provider software, right? So now if you're not changing anything, if you're changing basic as 50, will the PF not be automatically calculated on the higher amount? Right. And we are in a difficult situation. I hope there are no payroll vendors here, but still they don't take me wrong also. Sorry. They don't take me wrong. Many times what we do is, I don't call it laziness because it's tough to change the algorithm or mechanics in it. So we simply say basic 12% is PF mudunjirchu. It's not that way. So we don't want to change the basic now. One point I agree is let's not change the basic now. But for the purpose of gratuity, add the delta. How are you going to deal with your payroll vendors, payroll system providers? If you're doing it in-house, You should be thorough to know which of the components are excluded. Now, going back to my definition, these are the exclusions that are available. In my first scenario, I have some 30 extra, right? Special allowance. This can be realigned. And I'm not quoting because you will be coming to me so that I can do a restructuring advice. I'm just saying because this has come from Secretary herself. Ministry of Labor Employment, IAS officer, she mentioned that this is the time frame where we have to use for realignment of compensation. So by realignment, there should be a degree of reasonableness that should stick on to it. Right. So what we can do, if there is an other allowance or a special allowance in your compensation structure, you can take the goodie points by talking to your CEO or your MDs or your CFOs by saying, here are the components that could be excluded. Can we do it? Now, I heard one of them asking the question, how this can be restructured. It's an open secret. There is nothing so challenging about it. There is only one way where this could be restructured. Some pay to defray special expenses. That is the one line item where there is no clarity given, right? So whenever there is no clarity, that is where we play around. Right? So if your organization is not providing conveyance allowance or leave travel, the reason is because thanks to simplified tax regime, nobody is bothered about different structure now. And almost 80 to 90% of the workforce is going for existing, simplified tax regime, where they are not claiming deductions or exemptions. So companies are also not looking at restructuring or revamping their compensation. That's the reason. Right now, because of the labor codes, now when you are coming into it, if you have special allowance, you can try to fix in any of these components reasonably. Right? You provide everything and you give the conveyance facility and then you ask for conveyance allowance also as an item. I don't think the literature marry the fact. So we all take one aspect. This is something very painful also. We go by the definition. We can say conveyance allowance excluded. I'm going to add conveyance allowance into my compensation. But factually, you provide car facility or bus facility to your employees. Then what is the point of including conveyance allowance? So whenever we are approaching this realignment, see that your fact and the structure and the literature and the policies, comp and ben policies marry well. Right. Now that's where the one area where we can play around is some pay to defray special expenses. You can consider something like professional development allowance, because that is anyways linked to the development of the employee into that particular career focus. So we can consider that. The trending component that is in the market is gadget lease. Like car lease, you have gadget lease, which will anyways be carved out. Both tax benefits will also be given. So these are the areas where you will have to explore based on the fact pattern of your organization and then realign the compensation. Now, how many of us are with me that in the first scenario, it is not going to be 50, it is 80. Now, if everybody is convinced, my job is done. We are all convinced that it is going to be 80 as per the definition. Thank you. So if it is 50, then you will have to fight for it, or we can wait and watch because we have the rules to come in by any circular if they are saying in. Because we have also posed a lot of questions to the ministry officials. What we are hearing is they will come out with handbook on different FAQs, handbook, and different items that will have been part of the compensation structure, and they will call out whether these could be excluded, how this can come out with. So they're moving to a facilitation approach. On seeing it, we can try learning it. But given the limited time frame of 1 or 2 months, you can start exploring if your compensation structure has or has the capacity to accommodate new components. So that's how we'll have to first plan for it. Now, if we go back to this example, I think we will get the answer right. So 25,000 is my total, and in which I will exclude those that are not considered as a part of my wage, specified exclusions. Commission is typically sales commission, conveyance, so 13. Now I compare that 13 with 50% of my total. So there is a delta of 500. So the 500, I will add it back. As simple as such. So now it is becoming 12,500. So if you are trying to answer me saying that I'm keeping the basic as 50, mind you, you will have a tough time with your payroll processing teams, because your basic will again go for a toss. Why do you want to incur when basic is when PF is not even disturbed? So you can keep the delta separately. And there may be questions. I ensure if Anand touched about it on variable pay, performance incentive, one-time compensation, because when I say it is all remuneration, even my performance incentive will also be covered, right? So and it is one time. We don't have clarity right now, but what we understand from the discussions is, and it is all available in the public media, is that any irregular components can be ignored or cannot be considered for this position. If, for example, if your company gives a quarterly incentive, then becomes a regular component. If you're giving an annual incentive, then that will be out of the entire bucket or red, green basket, whatever we call it, it will be out of it. But we have to wait for the clarification to come on paper. Now, having said this, let's do, see, usually we get attached only when we see numbers. So I'm not going to take you through numbers, but I'm just going to tell you how this amount is getting changed, right? Almost one time or two time we see change on account of the gratuity payout. That is the reason we are requesting if there could be a realignment that is possible. Now, you might have a question. Act is effective 21st of November. Rules are only awaited. In gratuity chapter for calculation, there is no rules prescribed at all. So that means if an employee is about to get a gratuity by December 18th, what is the amount that I can still pay? One can take a conservative position. You can pay it on wages, but it will be very tough to recover from the employees because right now we still do not know what the rules are getting translated to. So we can pay based on the existing provisions because the notification also clarifies till the time rules are getting into effect, the existing provisions will be considered. Now, having said this, how do you protect? You can obviously take a legal opinion as a backup, or you can tell your employees once the rules are finalized, if there is a delta, we will pay it. There could be some interest amount. But my suggestion is we'll wait for the final rules to come. We can go in for what is available in the existing provisions and then take it. Similarly, how do we account? Right now, this is one area where once the labor codes are announced, we see a lot of interactions between finance teams and HR teams. Usually, they work in silos many point in time, except for passing the accounting entries. Now, everybody is so keen to understand what is the changes that the HR team is going to bring in. Okay, how many of finance people are here? One. Okay. Great. So thank you. So now all these HR folks will have to convince your finance folks that this is the implication that you're trying to reduce or bring down by realignment or by effectively planning your compensation. And then on the accounting side also, what is the number that we are going to give? Because December closure would be there, quarter closure. Then in March closure, we do not know what is the number that we are going to provide. So we should know how to assess it, go through the wage definition, apply it in your compensation, see the impact, then realign the number. Now, does it stop only here? Because I've mentioned 2-year FTE still be covered. Now, again, you will have to rework with all your workforce categories who are all falling under fixed term employees. Would there be a way if that could be remodeled, or is there a way can we bring them on roll? Something, a question which we'll have to take. I would also like to refer to one section which says that the section actually prohibits, the act actually prohibits, the employer cannot reduce the wages or reduce the benefit because of the application of this code. So if you are trying to do bringing in the employee, fixed term employees into on roll, if the officer will view it under that section, we may have to position it in a different way strategically. So there are checks and balances that are already in place within the legislation, but we may have to be mindful of that. Now, the next point which I would like to say is about the contributions. Again, there is an increase in the contribution. See, we would have paid 4.81% on the basic. Now it is going to be on the wage, as simple as such. So if anybody is coming and telling you that labor codes is going to be very tough, very difficult, the answer is no. Because of the financial impact, we are getting overexcited. Now, the government also saying there is a way to, adjust or realign. Why aren't we doing that? So we'll have to realign. And we also see there are practices in an organization which is not documented. We do provide a lot of benefits which are not coming in. We then, for the sake of provision in our policy, we mention it as allowance, but it could always be a reimbursement or a benefit that's coming in. So please capture that well in all your HR policies so that we know what will be covering as the base for the wage. So any questions till now on gratuity part? Rest of it is going to be English. So, I mean, only literature onto the screen. So, number part is done. So, any questions till now on gratuity? So, we are all clear. And so, now from the third session, the fourth session, we are convinced it is 80 and then we are going to realign the compensation. Okay. They're sending the questions. Okay, fine. Because it is going to be monologue going forward. So, only more maternity benefits. So, I thought there is no change in maternity benefit provisions like how it was previously. The same one is going to continue along with the leaves that are prescribed, the paid leaves. And the only change again is what is paid on the earlier base will now be on the wages. Other than that, I don't see a drastic change in maternity benefit provision. But what is throughout the code prevalent is if there is a benefit that is availed in one legislation, it cannot be availed in another legislation. Say, for example, if you take benefit under ESI, you can't take benefit under maternity benefit. If you take benefit under ESI, you can't go on for employees' compensation. So that is the only check that has been kept throughout. Otherwise, it's more or less the same. The new aspects that are coming in, which you would have already been familiar with, is the crush facility. So we have this crush facility announcement coming in. Most of the organizations are effectively planning for it. Either they provide it as a reimbursement, or they make sure that within their community they have a crush. Say, for example, DLF IT Park has a crush facility within them. So can this be deployed because it is accessible to the employees throughout for all the companies within DLF IT Park? So can we try that way? The rules are not released, or the scheme is not released yet for crush, but this is the logical one. So 4 visits to be given, nursing breaks to be given. We are not inhumane. Sometimes it pains. I know I'm sounding philosophical or social now. We never say a mother not to go, do not nurse. But the moment it is put in the code, what I feel is there is still a part of the country which is doing that, right? So whenever you are in a position where you have power, you have access, you have authority, please ensure that this doesn't flow through the act, it comes through the heart. Right. So now next on the unorganized gig and platform workers. So this is one area where we have more schemes that we are waiting for. We don't have much of the schemes or rules right now available, but the schemes are already framed. We are just waiting for the schemes to be released. Maybe after the rules, they would release. Have you ever wondered why they have not pre-published the rules before and why they are doing it on November 21? Any sanctity around November 21? One, of course, people know that it is because of continuous elections in state and center. They were pushing it from 2020. And there have been numerous, stakeholder discussions that would have happened. The other one is, according to a constitution, for only when the act is enacted, legislation is enacted, rules can be notified. So now it is giving us an additional window, and it has become like a tiger story. People were thinking, okay, it is not going to come. In fact, I have scrapped all my printouts of labor codes. I thought it is not even my revenue item. I can't talk to my clients about it. But then one fine day we get to know that November 21st it is becoming effective. So that's the reason once they announce the effective date only, they can release pre-publish the rules. And pre-publishing the rules, they can't say that because we've kept it already, the same rules can be published. No, because after releasing in that point of time, there are various chambers, associations have made representations. So that's why this another 45 days is given for us, and another 20-30 days to consolidate those feedback and then release it as rules. The indication is April, but we think they'll be still liberal to have this implementation in another more than that period also. One is for implementation, government has to be prepared, which they are convinced that anyways the PF portal is already well equipped, right? So they may try to add on another one linking it to the PF portal. We have to wait and watch. Two, they can say this is effective April, but the stringent provisions may come a little later also. Now coming back to this one of unorganized gig and platform workers. As I told, it's more texty. I'm sorry about it. I can't be as lively as your first session, less of problems, and as jovial as your third session, more of confusion. So this is very clear. So we have to wait. So in your organizations, if you are engaging freelancers, right, then a particular amount of your contributions, particular amount from your turnover, 1% or 2%, should be given back to the government to a particular fund. The details would be provided in the rules. But say, for example, Swiggy or Zomato, on their aggregate turnover, 1% or 2%, they will put it into that fund. Maybe a few months, last year, a few months back or on the end of last year, there are schemes or announcements that is talking about migrant state worker registration, e-Shram portal notification, and gig workers registrations. All there were a lot of points, and in fact there were many notices issued to textile companies asking that you employ a lot of people during Pongal and Diwali. Where are the details coming in? You pay them like daily wages and going in and all. That's exactly where now we are going to head to. So all these details will have to come in. So in your organization, if you're engaging a freelancer, just do a registration. The gig worker will also have to do the registration, because you are not going to transfer the benefit to the gig worker directly, right? It is only the contribution that will go to the fund, and the fund will take care of their insurance, and they will take care of life and disability, health and maternity, old age protection, education, and all local items like injury, taking care of injury benefit, housing, scheme for children, funeral assistance, old age homes will be done by the state. Very simple. Anything that can be done at central level can be done. Locational things, state government will have to do. So we have to wait for central rules. We have to wait for state rules for this scheme to kick in. And now what is this fund could be made of? It could be made of the contributions from state or central government. CSR fund can also be allocated into it. So if you have some CSR fund, so that can flow in there and then create this fund for unorganized gig and platform workers. And any contributions and fines that are all collected can also come and sit into it. Now after this, the point is on the aggregator platform, same logic. So you have from their revenue, the contributions will go in. Now, for us, what is the impact? If you are not working in all these platform worker, there is no platform model, there is no challenge. But what we are seeing as a trend is many times in our organizations, we recruit people, or sorry, we deploy resources for a particular task. Okay. In that situation, if the task is only for 11 months, fixed term employments, if it is for 11 months, it's okay. Because 1 year is where that gratuity trigger. Again, my ask is let's not do it like a rental agreement where every 11 months we put so that we don't register and then keep renewing it. So be mindful that the legislation is viewed substance over form. It's not mere consolidation. It's not mere words in the paper. It is how we do it. So your process will have to be analyzed. So if you are discussing within your teams, analyze your process first. Before even you come to consultants or legal practitioners, note down what your processes are. Analyze it, document it, then approach where this could be done for. I think I have only few more slides to cover, but still. The other features, digitization. Most of the records, what you must have also heard, it is a single return compliance going forward. So we will have one for PF, rest of it will have one return. When you find time, please go through it is already available in the previous rules. It's some 5-page form. It covers everything, right? I'm wondering why the government took so long to bring that way. So you have labor consultants, right? So they're different regulations, different wage definitions, lot of confusion. So those are all now removed. And it is mostly electronic form. And what I am expecting is this could be merged soon with the PF form so that it is easy. We'll have only one form. You must have also heard about employment linked incentive scheme, right? All right. So how many of us registered? We don't know. Okay. Registered. Super. Thank you. So this is the classic case how the digitization has improved in our country. I know I'm just diverting from the topic, but I thought it is still a social security. So if in your organization, if you have additional employees, per additional employee, you get 3,000 rupees as incentive. Initially, when it came in, there are a lot of noise in the market because people felt, how would this be administered? அதுக்கப்புறம் extra கொடுத்துட்டா நம்மளே DD கொடுக்க சொல்லுவாங்க. We have to go back. It will appear as demand in my portal. I'm not going to register. Now, the government has released FAQ and then clearly said that there is no job that has to be done from us. Only two things. One is the registration that you are willing to do. Second is quote the right gross wage in your PF ECR. That's all. So if the gross wage is less than 1 lakh and if the employee is staying with you for more than 6 months, then you are eligible. The question is it applicable for lateral hire? The answer is yes. If it is for replacement, it may not be, but for additional employment, even if the person is a lateral hire, employment linked incentive scheme will provide incentive. So if you have not done in your organization, just check, see in your PF portal, check with the different team, see if it's more beneficial to you, unless you have an expansion mode, right? This would be, without touching anything from your pocket. It would be directly credited to your bank account and the PF officer will do all the algorithm on its own. It's not us who are going to do it. Why am I bringing that point here is, when our government has that amount of digital infrastructure that is ready, it is easy for them to capture all these things in one form and bring it in, right? So where we'll have to be conscious is just clean up our existing data. If you have multiple numbers, if you have dues, we have seen components that are no longer existing, but still having it for the sake of having. We do not, except for the 200 rupees, 200 into 12 education allowance, we don't know why that component exists at all, but still we have it. So please consider whether those are relevant, go through your compensation structure and then add it into a cleanup activity, right? And similarly, for those who are having your existing trust, make sure that the old dues, as much as possible, any awareness could be created so the employees can come back and get that sorted, because anytime there could another be notification that would come in. Instead of doing a firefighting, we can be well prepared. Now, the next welcome move is under PF. Okay, maybe this could be the reason why Anand would have left it to me. PF Act doesn't have limitations. We know, right? Limitation is something where they can go back any number of years. So at least in Income Tax Act, we have certain numbers. Black Money Act, we have 16 years. But for PF, nothing. Adnalda, whenever the Supreme Court decision on pension and provident fund come in, it was so easy. People were all explaining. I still remember in MMA, I attended a conference. The speaker was saying, "Madam, this is just from left pocket to right pocket, as simple as such. You apply, you get it." But how many of us have got in Chennai? The answer is zero, because RPFC themselves have confirmed that no applications were processed in Chennai for this higher pension scheme. It is as simple as putting money from left to right pocket. But still, it is not processed because there is no data available, and we don't know. Our organization could have been 20 or 30 year old. There are many organizations who have lost their records, paper records, in floods. They would not even bother to keep it. And thankfully, or unluckily, unfortunately, what happens is PF officers are not able to confirm to the number that we are quoting. Despite we give a confirmation, can we go by the existing one? Right now, for all those limitation related issues, there has been a full stop. So 5-year limit is there to initiate any inquiry. So technically, you can be managing with the last 5 years or from 5 years. That's one savior point, which I personally feel. Otherwise, see, I'm working in an organization for 12 years. I am the mailbox for all my clients. So most of them will say, Kavita, 2013, this issue has happened. Can you forward that email? Because we don't keep it that way, right? For PF especially, we have this challenge. At least for income tax, we have some benefits, but PF, we have the strict challenge. So my request is, now at least we have 5 years. It's actually a blessing. And the other one, even more a good one, is within 2 years they have to complete. They can't drag. I have cases where even Anand is handling, is going for 6-7 years, because it's only every time when we go, the tribunal, they say it is not office, the authority is not there, or there are more cases, we are going to give it for next year. I know for 6 years, 7 years, the case is still happening in the tribunal. But now it is a mandate that within 2 years they have to complete. And if a petition is filed before Central Provident Fund Board or the Commissioner, within 1 year they can insist to complete it. So that way they are trying to quicken it. So what does it mean? It could be happy on one side. The other side is we should be having all the facts with us ready. So please utilize this window for that. Then reduce deposit of appeals. And again, this one is a vague one. Whenever we go for an appeal, the challenge is we are not satisfied. But further, they will ask us to pay 70% of the demand with no interest, right? So this is something which I am personally not okay with. But it could be 50, it ranges from 40 to 70%. For any appeal, we pay that as a deposit. Now it is restricted to 25%. So for all appeals, if you are going in, it is only 25%. Next is for construction workers. I am not sure how much relevant this would be for the crowd, but there is a self-assessment test that has come in. So we can't take construction workers for granted, because they also need coverage. So 2% of the total cost of construction should go in there. Now the challenge is, we do not know what would be the cost of construction that's coming in. Now, one way, if we are constructing, we can always ask your constructor or the builder to show that sheet, and then know how much he is reporting, how much he is charging us. Then we know if it's an excess, we can always find that out. Otherwise than that, for us, may not be much relevant. Last but the previous slide, this is on decriminalization. We must have also seen that we can unlearn, learn, relearn, but are the officers going to do that? We'll have to wait and watch. Because I have seen personally, officers will always work like a CBCID model, or a due diligence officer, or a vigilance officer, as if I've done a great crime. Now, the entire legislation is in a way that it's moving on into a facilitation approach. As you see in my third point, it is inspector come facilitation. I don't remember the series that I watched on Netflix a couple of weeks ago, but it says they have a confusion in the office. They do not know what to do. They don't go to a consultant. They will go to the authorities directly, and they will ask, boss, I have this problem. How do I address that? This tax issue has come in, kind of. This person has gone, and how do we do that? That is exactly what we are trying to see in now. So now, if there is any issue or if there is a compliance question, we can straight away approach the officer. Now, what would happen is, so if we are approaching, will we be criminalized? Will we be penalized? No. There is a 30-day notice of improvement is given. That means there is an opportunity is provided for us to clear all our non-compliance. So this is one way, like our amnesty scheme, we can call it out, and for every issue we can pick it up. But they are also very clear, it could be only for first time. A repeat offense is always punishable. So for the first time, it's okay, it is decriminalized. And compounding of offense, as we know already, we have this quite a practice in tax. Now we are bringing it in the social security also. 50% fine we pay instead of dragging it. It saves a lot of time. That's how the legislation is coined. An inspector come facilitator, yes, we have touched. And in fact, I will see if I can circulate that press release. Government in the press release itself, it says income tax officers are doing policing task. It comes like that in the press release of the government. So instead of policing, they will have to facilitate. That means they ensure that the compliances are flowing through. The last but not the least is the career center. It is a sophisticated employment exchange, we can call it. And government is also trying to improve. It cannot be on paper filing, it's going to be online. Now, what could be the role of placement officers or HR consultants who are having most of the monies through positioning the profiles or placing the profiles? We'll have to see how this would translate into, because we have seen many of the HR consultants who will have sourced a lot of profiles and share it for talent acquisition team or recruitment team. Now the government says the vacancy will have to be reported to the career center first, right? And in the career center we'll have all the details, and we have to see if the career center profiles are first matching to us. So all the HRs or in the talent acquisition space, your first step is to approach your career center and not any consultant now. And then if it is not, and I've gone through the profile, and thanks to this opportunity, otherwise I would have also not gone through the form. The form clearly says that if you are not getting, if there's a shortage, that if you're not able to source the profile from the career center, you have to give the reason why it is not sourced from the career center. Right? So we don't know for whom the hit is going to be, but practically the reporting will have to go through and we'll have to source from the career center first. And they're also expected to do vocational training. So they will have to train on basic communication skills or whatever is relevant for that employment opportunity. So this I'm skipping because it's more of numbers and penalties. So no. So I ain't very comfortable talking from the podium because anyways my slides are done. But what I was to say is, now that let's approach it positively. Let's not have much fear or trauma around it, because having gone through, and it is not much because of the unions or negotiating councils, I'm not getting into IR or OSH code, but from a code on wages or on code on social security perspective, please do a cleanup activity, go through the compensation items that you have, align what is the wage. So it could be maybe something like a financial impact or a non-financial impact that we can do, something like a process change. Right? If it's a financial impact, you can assess how much is the impact. Now, there are situations where we have seen at least 1%, 2% only increase could have been there. So you can either protect your employees by bearing those costs. Say, for example, if the gratuity contribution is part of the CTC, many organizations have that, right? Gratuity contribution is part of the CTC. In that situation, there could be 0.5 or 1% impact that may come on the take home of the employee. Are you going to bear that, or you're going to reduce the take home? If you reduce the take home, will that section trigger? Section 124 will trigger. So we have to be first prepared. So anyways, you would have got your November payroll dump by now, right? So let's start thinking from that perspective, what's the impact? Realign the compensation for the revised impact and then see what could be the erosion in the impact that's coming in. And workforce arrangement. There could be convenience where you have FTEs. Now the FTEs would be moved and people prefer to go in for an on-roll employees. Now whether on-roll employees are still required or not, that is an analysis that you have to make based on your organization structure. Then framework, yes, whatever is done in the office is not going to matter anymore. It has to be documented in paper. So please do update policies. I think in OSH code they must have covered women employees, safety and all. I don't think any organization say 11 o'clock mala poitu amma enaku unakku sambandham illa. Nobody. Everybody ensures there is a cap facility that is provided to the women employee. But still, in my view, it has to be covered across both men and women. As a society, still view both men and women together. But needless to say, it will come in a few months. But what I am expecting is that process should be captured in the policies, and it is all with the HR to do that. And wherever new policies are required, SOPs are required, please build in so that you have complete authority or what is going to come in for us respective. Communicate it to the employees. Have we communicated to the employees? When we ourselves are not clear, what are we going to communicate to the employees? See, they are also exposed to the same amount of news that we have, but they may not be attending sessions like us, right? So what they would do is they will either feel whatever change that you are going to bring in, they will feel it is going to impact their take home. Like that only the mindset could be. So please ensure that you adequately communicate it to the employees and track the updates. And every day there could be some development that will keep coming in. So track the updates. And once implemented, don't stay cool or leave it to your payroll teams or your finance teams. As HR, please do the due diligence, because at the end of the day, if any question comes in, it will come to you, who will have to face the authorities. So with this, I would really thank you for this excellent opportunity. As I've told, most of the interesting parts are already covered. I think I've done justice to the time that I've given. So let's not panic. It's as easy as such. And that's how I have approached it. And any questions, I'm open to take now. There are no questions. I assume that I have done 100% right. IR optional illa sir, only code on social security. How can the overall 50% wage structure be divided among various components? And what is a typical percentage range for each component? Okay. So, Rashekar, we do not have a structure that is given or a template that is given by the government as of now. In fact, even in our previous ones, there is an internal circular by PF office that says if 40% or 50% is the basic is there, then we need not worry about inspection. That is an internal circular given to the PF office. So as of now in India, we don't have this panel done. But my suggestion is if you have 30 or 40, retain that. But whenever you're doing a restructuring of special allowance, put it into professional development or conveyance or into those exclusions. Make sure it doesn't exceed 50 so that you do a delta every time. How should organization forecast PF and gratuity caste impacts and new wage and redesign pay structure? Okay. Thanks, Hema, for asking this question. So one is without hurting employee confidence is one crucial factor where you may have to communicate to the employees that this is not done to impact their take home. First confirmation. Second confirmation, PF, there is no change at all. So let's be very clear in that. On the gratuity, only if it is part of the CTC, there is going to be a change. So there you take a call along with your business, you being the business partner, whether this has to be borne or not. But the immediate task is please communicate some awareness to the employees. Maximum amount of gratuity payment on COSs, yes. In code it is mentioned the existing things will continue, so 20 lakhs. But still if you want to pay over and above, it's still fine. EPF, ESI, maternity and contract, how should organization reassess workforce models? Okay. Malini, to answer your question, it is purpose driven. So you can't simply put in one employees, I'll put everybody onto on roll, then what is the rationale of changing that conversion? See, you have a seasonal deployment of a particular task, right? And if you're putting them into on roll, whether your business will absorb the cost, one question. Vice versa also holds good. If you have an on roll employee and moving them to fixed term, 11 months and renewing it, that will be viewed as ultra vires the legislation. What key systems and tech integration should companies prioritize to digital compliance? Okay. First is your payroll vendor should be equipped enough. What we also hear is they are also revamping their payroll software with whomever we are interacting. Payroll software to capture different base and then they calculate the wage. And as HR person, please validate the wage like how you do a review every time. Is the construction industry covered under ESI or construction site workers? Yes, the coverage is there and also construction contributions are also being provided. The employer will have to pay 1%, 2% of the cost of contributions. The social security deputation structures. Okay. Prem, now this would be a typical point which anybody with mobile population will be worried about because tax, social security equalization with gratuity also the money will go to the employee because for an employee since it is a labor related benefit we can't recover it from the employee. So now we'll have to either position it as an on roll but again FRRO will not agree to it. So this conundrum will exist till we have some exclusion coming in for. If conveyance allowance is paid uniformly to all employees, is it excluded from PF wages under the new wage definition? Okay. This regularly, uniformly is what we are talking about is for the one-time one or the irregular payment. Even if it is paid as conveyance allowance, it's still an exclusion because it's falling under an exclusion basket. There are so much of questions. If a full-time employee is transferred to an acquiring company after having worked for 3 years, yes, the benefits will still continue. The transferee company is still responsible. If there is a lack in that, they'll have to be equally considered. If the transferee company is not doing it, the past company should also take care of it. So person under consulting agreement providing service being considered as an FTE, depending on what the agreement provides for. If it is like a B2B contract, that's absolutely fine. If it's on-premise where they'll have to work for a particular project, they would be considered as FTE. Compensation Act in the new code, not much except for that which I have told about the commutation accidents will also be covered for compensation. Allocation of gratuity, is it still hold good? Yes, Anthony, right now the rates are not changed, but the moment we get the final rules, we'll know the rate. There is a production incentive paying on monthly. Okay, production incentive is not covered under the on the exclusion. So only sales commissions are there. So if it is not covered under the exclusion, it will be still covered under wage. Okay, gig worker will be provided with insurance. We'll have to wait and watch how the gig worker scheme are coming in for. Any changes in the ESI benefits and eligibility criteria? Right now, no, Muthu, because it as of now it says the existing threshold will apply. PF file, we need to mention gross wages, new code will, okay. This is PF is not yet repealed and we'll have to wait for the final rules. Until then, you can go with our existing gross wage wherever ELI is applicable also. Have two base till, no, this is definitely not going to be, this is an interesting question. How many of us have even thought of, see, we get monthly or annual increments, right? Even now. If last year, in the year, we would have got 10% increment more. Are we calculating gratuity in that way? Like previous time, it is minus 10% and now on 10%. No, right? Then this question, I think, what I feel is it absolutely on that line? So even if there is a change, it should still go on because we have our change that is happening every year. So there is not going to be an impact on account of this code, logically. Uniformity in PF consideration for international workers and Indian employees. We don't have a specific provisions for international workers. Good. So that means whether the gross would continue, can they be applied on wages? Yes, we can apply on wages as on date the law stands good, but they'll be subject to the gratuity, which is our fixed term employees. If an employee works 7 hours every day instead of 8 hours, can the employer reduce the salary based on hours? CJ, I am not sure if I can answer this question, but to my understanding, if it is provided in the contract, then we can't reduce the wage. If it's like from 8 hours, if you are moving to a part-time or a flexi time, then the compensation will have to be revamped and agreement will have to be signed. Can be availed from government as like an EPFO if employer having trust. Yes, the clarification says you can still avail it, employment linked incentive scheme. If a full-time employee is transferred to an acquiring company after, I think I've answered this question. This is covered. This is covered. There is stay in Supreme Court for construction company ESI. Okay, I ain't very sure about the stay, but right now with this new codes, anyways, we'll have the specific contributions that would come in for the construction workers. Within 2 days, I'm having an account in LIC. As I've told, in the code on social security, is talking about 30 days. We can wait and watch for the clarification, the full and final settlement, whether it will comprise gratuity or not. PF is must for FTCs. No, right now for FTEs, the fixed term employees, gratuity is only mandated. Let's see how it is translating otherwise. Right?
I think there's a questions are.
Almost all questions done. Oh, great. Thank you so much.
I think more than a question answer, it was a rapid fire round actually. The way she was taking on questions. Thank you so much. Yeah, good, ma'am. No, very nice. Thank you. May I request Group Cap Vijay Kumar and Mr. Matthew? Yeah. Ma'am, we'll request you to accept a small memento from MMA and NIPM. Let's give her a big round of applause. Thanking you, time off.